All right, and we are now recording. So welcome everyone. This is our last event for the Arlington Democrats, focused on discussing the proposed constitutional amendment for redistricting reform in the Commonwealth of Virginia. Just to remind, my name is Maggie Davis. I'm the deputy chair of the Arlington Democrats. This is our third event. We had first at the end of June a roundtable on the issue that included 3 people that supported the amendment and 3 people that opposed the amendment, including Delegate Mark Levine, who I see has joined us again today. So I'm going to leave a link to that roundtable in the chat and encourage people, if you have not watched that roundtable, it was really well done. I highly recommend it if you still want to learn a little bit more. And then this is a follow-up conversation to that roundtable conversation where we, for the last morning mug and this week, have focused on the constitutional amendment. Last week we focused on grassroots activists that supported the proposed constitutional amendment and had Chris DeRosa from the Arlington Democratic Committee present reasons why she was a grassroots supporter of the constitutional amendment. This week we are focusing on grassroots activists that oppose the constitutional amendment. And we're going to hear from Mr. Craig Hines. To remind everyone kind of why we're having this conversation, the current Constitution of Virginia has the power of drawing legislative districts, the sole power of the General Assembly. Over the past several years, there's been kind of a grassroots movement to change the current process that we have for redrawing maps out of a concern of gerrymandering. And believe everyone on this call knows what gerrymandering is, but it's generally the idea of drawing districts to improperly, dilute or compact power into a district so you do not have as representative of a vote. That's kind of the general definition of gerrymandering. And under the law federally, it is illegal to have a district drawn in such a way that it either impermissibly draws districts based on race, or it's mostly race. Those are mostly the ones that they have found to be impermissible gerrymanders. Right now, we are about a year out from redrawing our lines. At a minimum, a jurisdiction redraws their jurisdictional or legislative districts every 10 years tied to the U.S. Census. So the U.S. Census is currently happening this year in 2020. If you haven't filled out your census form, please do it. Next year will be the process that we go under to redraw the district. So that's part of the reason why the constitutional amendment has come up at this time, because the idea would be that should the amendment succeed, this new process for drawing lines would go into effect for the 2021 process to redraw lines. For kind of general background on constitutional amendments, in the Commonwealth of Virginia, to have a constitutional amendment be enacted, you have to have the same text of the amendment pass the legislature twice, 2 years in a row, with an election in between. So in 2019, a version of this amendment passed the General Assembly. We had an election in 2019, so in the General Assembly session in 2020, that same version passed again. Now the amendment is coming to the voters. So on the November 3rd ballot, you will see a ballot measure asking whether or not Virginians want to amend their constitution to include this commission to draw legislative districts. So where we're at now and why the Arlington Democrats are hosting these series of events is that the Arlington Democrats need to decide whether or not we want to take a position on this issue. So at the end of the month, the steering committee is going to vote first, whether or not to weigh in at all, and second, if we weigh in, whether we would support or oppose the amendment. I want to say, I've said this before, we have a lot of different views on this particular issue within the Arlington Democratic Committee. Reasonable minds can differ here. This is a really thorny issue. There's a lot of nuance in it, and there's a lot of people that are really passionate about it on both sides. and kind of a lot of people that are still trying to figure out exactly what is on the table. So we have really urged all of our voting members to really educate themselves on this issue, as well as on what the exact proposal is on the table. So with that, I think that covers everything kind of as a background. General kind of schedule for today. Craig Hines, who is one of the grassroots activists that opposes the amendment, has a presentation and is going to give an overview of why he opposes the amendment, and then we'll have an opening for some Q&A. I see in the general group chat, we both have people that are strongly in support of the amendment, as well as people that very vehemently do not think it is the right move. So I think we're going to have a robust conversation. Just kind of as a last reminder, we're all friends here, so we're hoping this is just going to be a very and a congenial conversation where we're going to have some differences of opinion. But really the end outcome is we want to make sure that people that are voting on this issue know what they're voting on and make a really well-informed decision. So with that, Craig, do you want to start?
Sure. Thanks to the ever ardent, ever inclusive, ever even-handed leadership of the Arlington Democrats for scheduling 2 morning mugs to examine the proposed constitutional amendment on redistricting. Thanks, I guess, to Maggie for volunteering me to put the case against why I think this would be a terrible step into the abyss, especially if what you, as I am, are really interested in independent and nonpartisan redistricting. Let's go to the slides. I now just have to find the slides, pardon me.
And Craig, you need to share your, yep, there you go.
There we go. Okay. What's at stake in the proposed constitutional amendment? If it's defeated, perhaps momentary disappointment for some advocates. If it's adopted, a very consequential, hard to change, and political mistake for the entire Commonwealth. Let's remember what Eileen Fillercorn said. We must be vigilant and adhere to an extraordinarily high standard when proceeding with permanently changing the Constitution. In my opinion, this amendment fails to meet that standard. Also remember, Virginia Republicans love to use or attempt to use the Constitution of Virginia to mess with people and their rights. 2006, 2 Republican legislators, Marshall and Newman, sponsored an amendment to outlaw same-sex marriage. Shamefully, it was adopted. It was ruled unconstitutional in 2014, and at least currently of no effect, but it's still in the Virginia Constitution. And then just in 2016, 2 Republican legislators, Owen Shane and Dickie Bell, put forth an amendment as Democrats begin to retake seats in the General Assembly to put the right to work for less law, anti-labor provision, and put it in the Constitution of Virginia. Voters rejected the foolishness, but Republican majorities in 2 successive legislative sessions had tried. So what's up? We're being asked to vote in the proposed constitutional amendment on November 3rd, or to consider as the Arlington County Democratic Committee. As one of the proponents suggested last week, advocates of an amendment were looking for a fine pate, but what rolled out of the General Assembly has, quote, some sausage. Should Virginia put some sausage in the Constitution? I think that is sort of like Thomas Jefferson meets Jimmy Dean. And then in the words of another proponent, it's not perfect, I'll grant you that. What did Arlington Democrats ask for? We've been proactive on this. As the General Assembly began in 2019 to consider redistricting amendments, Arlington Democrats asked for an independent redistricting commission and a nonpartisan redistricting commission. Resolution still on the books. Independent, nonpartisan. Remember that throughout this debate. Remember it as you vote. Remember as you talk to your neighbors and friends about this. What Arlington and Virginia got in this proposed constitutional amendment is neither. It's neither independent nor nonpartisan. For instance, look at the proposed commission. All commissioners will be members of the General Assembly or proposed by members of the General Assembly. All. Or to put it another way, commissioners whose appointment will be truly independent? None. Zero, zip, nada. But the General Assembly wasn't quite through putting its thumb on the scale. Where would all of the judges or justices who will or may be involved in the process, including possibly drawing legislative and congressional district lines, come from? They would all, each and every one, have been installed by the General Assembly. Not to put too chummy a point on it, but one of the justices is a former member of the General Assembly, both House and Senate. One justice is the sister of a sitting senator. One justice was senior appellate counsel to Ken Cuccinelli. Proponents claim to have the high road, but they don't like to admit a simple fact. There are no guardrails on their high road. If it comes to the Republicans' poison pill, there is no guidance for the Supreme Court, which would then draw the districts. No enabling legislation, no criteria. Zero, zip, nada. The applicable enacting legislation and language is simple and direct. The district shall be established by the Supreme Court of Virginia. Unadorned, unguided, the district shall be established by the Supreme Court of Virginia. Which is, by the way, the Republicans' dream. House Minority Leader Todd Gilbert said in May he was amazed that enough House Democrats had fallen for this proposed amendment in two successive years. And read down to the boldface, if we play our cards right, we could position ourselves to be back in charge of the House. I don't know what the proponents of this amendment don't understand about that. It's very clear. Todd Gilbert wasn't joking. He wasn't laughing. He was amused that they'd gotten enough Democrats to vote for it. But anyway, just keep that in mind. Why would Democrats vote to do exactly what a Republican leader wants to try to do through a constitutional amendment that they probably cannot do at the ballot box? Any two legislative commissioners have an absolute right to reject the district maps and send the entire process to the Supreme Court. That's 2 commissioners out of 16. What part of just 2 out of 16 do the Democrats supporting this proposed amendment not understand? Republicans who support the proposed constitutional amendment know exactly what it means. They intend to play hardball, and that's their right. But why should Democrats give them the ball, the bat, the gloves, and the entire ballpark? Think about some other numbers. Out of the 76 Democrats who are now in the General Assembly, 21 in the Senate, 55 in the House, only 28 voted this session to send the proposed amendment to the voters. With an 86% vote, Democratic State Convention in June adopted a platform calling for defeat of the proposed amendment. The entire plank is worth reading, but here is the resolved language. First, urges all Virginians to oppose the amendment while still strongly supporting nonpartisan or independent anti-gerrymandering reform. 2, calls on committees to include opposition to the constitutional amendment on its general election sample ballot. And 3, urges all Virginians to vote no, but to continue to work toward genuine nonpartisan or an independent redistricting process. That process can be ready at the legislative level for the 2021 redistricting. Some argue that we cannot let the perfect be the enemy of the good, but that's not what we're faced in this very flawed proposed constitutional amendment with its sausage. And speaking of sausage, you can put lipstick on a pig, but it's still a pig. Thanks very much. I'm willing to answer questions. I'm sure people. I see a lot of proponents in the room, so I hope we have a strong, good discussion.
Yeah, and first I do want to mention something. Craig, you had brought up the position from the Democratic Party of Virginia, and this was mentioned in the chat, but I do want to say that the Democratic Party of Virginia, the resolutions were adopted as a package.
Yes.
So there was not a singular vote on the amendment. resolution. So
No,
I just want to make sure that that is.
But it's 86%. I mean, if people wanted to, I mean, they could have voted no. They didn't. It's 86%. I mean, that's what the point I've made.
I'm just going to say, as someone that voted for it, people generally didn't have time to read the entire, like, 500 pages.
Well,
Not
that's
that
true.
that's an excuse.
That's true of this
I
amendment, too.
Sure
People haven't read.
I just want to make sure that, like, one, that was not independently voted on, so it's not exactly representative of.
It's there. I mean, I get what you're arguing, but
no, I just want to make sure that we're clear on what that number actually represents.
But I don't think we ought to denigrate the voice of the state, of 86% of the state Democratic leaders who were at the convention virtually.
So I just want to say, just to kind of clarify what Maggie is saying, for those of us who were delegates, we were pretty much told you either vote yes or no. So if there were things in there you wanted, you had to vote yes for the entire package. So I think the point is it's not really necessarily reflective of the percentage of people who felt one way or another on it, because if there was something else you were passionate about in the resolutions, and there was a lot of discussion about how everything had been vetted. So it's not to say it's not valid, but I think the point is for people who were not part of the state convention process and the voting process, it's just to clarify how that process worked and what that vote means.
Having worked on platforms, I believe, and anybody who was involved this year, it was the most carefully vetted platform of any Democratic convention I've seen.
I'm just saying, Craig, to be clear, that the vote was for the package as a whole, not on that exact resolution. So I just want people to know we don't know what the exact vote on that resolution would have been.
No, we know what the vote on the resolution was, because it was part of the package that passed by 86%.
I mean,
can I say something?
The vote, that's the process, right, guys?
Yes,
I mean, that's the process.
That is the process.
So the vote's the vote.
Well, thank you.
May I say something about that in the state resolution package? So the resolution that was on the Constitution Amendment was not very well written, as you stated, Craig. I mean, the others might have been superbly written. But for example, that resolution was out of date, if nothing else. It was referring to the future passage or discussion of the Constitutional Amendment in General Assembly, when the actual vote was taken way after the vote was taken by the Democratic Committee long after the General Assembly had passed it. So if you read what it was written, it is not well written. It was very outdated.
Well,
it was written afterwards. It was written between the session and the convention.
And I apologize because I think I started this. The purpose of this conversation is not the validity of the DPVA vote. It's what will the Arlington Democrats do? So there are, again, reasonable minds can differ. And what I want to emphasize is that this is a vote the Arlington Democratic Committee is making as itself.
Right.
So we can take guidance from a number of places, but we are not bound to the DPVA vote. That is just my point.
The DPVA, which is the highest, Democratic body in the state, asks us to be opposed to the amendment and to have that opposition on the sample ballot. That's not unclear. Doesn't depend on when 3 words were written. It is clear. The party is opposed to it and has asked people to include it on their sample ballot in opposition.
And for the record, the Fairfax County Democratic Party, the largest Democratic party in the state, strongly opposes the amendment. They had a vote. It was overwhelmingly in opposition. And no Democratic party in the state to date has ever expressed support for this amendment, none of them. So we would be fighting with our fellow Democrats if we chose to support it.
Hey, Maggie, are we doing questions now, as Craig was suggesting, or are you going to wait?
Yes,
okay.
We can start with questions.
Do that end. I have a question for Craig.
But to that, Marcia, just to be clear, if people have questions, if you could please use your raise hand function so that we have some moderation. I had also gotten some questions by email.
Okay.
To add in. So
Marcia has her hand
Marcia,
up
go ahead.
Well, if you got email first, they're first in line. Anyway, so Craig, back to one of your slides, which sounded like something I had not heard.
Yes.
You made the statement that I think all of the members of this commission are either in the legislature
Yes.
now, that is to say, at concurrently with their stint on this commission,
You got it.
or they are appointed by.
Yes, 16 members will be members. There's 16 members.
Right.
8 will be members of the General Assembly.
Hmm.
8 will be people who have been suggested by the General Assembly and selected by former emeritus judges.
Hmm.
And those judges, by the way, all got to the bench through the general, by being put there by the General Assembly or confirmed by the General Assembly.
Sure.
So this is,
Yeah.
Plus this takes the governor out of it, at least in the current, way, the governor has some action. This cuts the governor out totally.
And to follow on just on the same kind of idea, because you were saying, yes, the judges are beholden to the assembly and they would be whatever. My question is, how do you avoid that? I mean, all judges are appointed. I mean, we don't elect our judges, right, in Virginia, so.
What do the judges have to do with it all? I mean,
Well,
any number of states have processes that do not involve number one, generally the legislature or the judiciary. Some states have a commission, and then it comes back and is subject, as some of this would be, to an up or down vote by the General Assembly. Part of that started in Iowa, and it became sort of an article of faith that you did not oppose the commission. Some of that has changed over the years. But remember, this would be in the Constitution.
Yes. No,
Once it gets in it,
I get that.
you ain't getting it out.
No, I get that. So my other question about this whole thing, though, is if we don't do this, I have 2 points. One is the hypocrisy, okay, that we've screamed about this for years.
No.
We've been on about this while they were in control, okay? Now
We've been on about an independent, nonpartisan commission.
I understand that, Craig, but you know as well as I do that most people do not make that distinction, will not know enough except to see that the Democrats, they wanted it when they weren't in power. Now they're in power and now they don't want it. I'm saying that's one thing to consider, maybe. I don't know. The other, though.
I have broad shoulders. I can take all sorts
Well,
of.
whatever. I know. But I mean,
from the
we don't want
public.
to be thrown out of office over it either, do we? So the other thing is next year, if we don't do this, right, we have to redo districts, right? Isn't it 2021?
Yes.
So what's going to happen if this isn't done?
My preference is that the legislature will pass, as Delegate Levine has a measure. Several people have measures that would, in fact, make the 2021 redistricting a fair process. I think we have worked for 10 years to get these people back in power. The idea that they're now going to get there and not do what we want them to do on this is I wasn't
aware of that legislation. So if that were
sorry.
So I just want to say, so to that point, yes, there are some legislative proposals. I put in the chat earlier the resource folder from the Arlington Dems that includes, I believe, a link to both the legislative proposals as well as the commission. But with that, I wanted to recognize there are a number of other people with their hands up. So to kind of keep the conversation moving, Dahlia, is it Dahlia? Dahlia, nice to have you back.
Yeah, thank you. So the question I have about these legislative proposals is, in 2020, we had a Democratic trifecta. We've been talking about redistricting reform for many years now. Like Marcia said, we've been campaigning on it, and there was, proposals that made it to committee for redistricting reform, some advisory commissions made up only of citizens. I know Delegate Levine had some of his own bills, and not a single one of them made it out of committee with a Democratic trifecta. So what we have before us with the amendment is the historic opportunity to ensure that there's a citizen-led, transparent process with additional protections for communities of color enshrined into our own state constitution. And I'm wondering, Craig, why you're so willing to throw out our only chance at significant reform for promises that the Democrats did not deliver on in 2020, especially considering that any legislation that passes in 2021, if it's a commission through a bill, it's purely advisory. And otherwise, an amendment will take 2 more years, which means it won't have any effect on redistricting reform for maps this decade.
First, it's not citizen-led. It's 8 and 8.
There's
and
a citizen chair.
There's a citizen chair. How did the citizen chair get there?
The citizen chair is chosen by the other citizen members of the commission. I included a graphic in the chat that explains how all the commissioners are selected.
They're all selected because they have friends in the legislature. That's how they're selected. Come on, let's strip that away. But I think it's entirely possible that you have a good bill. First of all, this legislature was constrained by the constitutional amendment process. What passed this year to even have a chance to get on the ballot had to be word for word, comma for comma, period for period, the same thing that was passed 2 years ago.
So that we could have fair redistricting in 2021.
I wouldn't use the word fair. Because as I keep repeating, nonpartisan, independent. This commission has nothing to do with being nonpartisan and independent.
So Craig, you're not answering my question, which is we've been promised that there's this advisory commission that could be established in the future.
Yes.
And I just want some clarity on why you think it's more worthwhile to take these promises that haven't been delivered on in the past when we have substantive reform in front of us that the voters can vote on in November.
I don't think it's substantive reform, and I don't want it locked into the Constitution where we will never get rid of it.
So you would prefer the status quo?
No, I don't prefer. I do not prefer the status quo. I prefer the legislature between now and the redrawing to come up with, as they will, I believe. I mean, you can say no. I mean, we just disagree on that.
So I will say, I think Delegate Levine wants to weigh in about the role of the legislature here.
I do. And of course, this week is supposed to be devoted to the opponents. I stood down. I didn't even show up last week for the supporters. But I think that given that last week, supporters said many, many things. In fact, I have a long list of things that actually aren't true that the supporters said, that we should give opponents a chance to make our case, because that's what this week is supposed to be about. In terms of what the legislature did and didn't do, it's important to recognize that the current constitutional amendment is an advisory commission, all right? Because all it takes is Todd Gilbert and one of the legislators he chooses, Kurt Cox, to say, we hate the commission, and the whole commission goes in the trash. Everyone should understand that's what they did in 2011. They said, Governor McDonald said, I have an advisory commission. Republicans threw it in the trash. It takes just Todd Gilbert and any legislator he chooses, and the whole commission goes in the trash. And the the Virginia Supreme Court decides this measure, which is appointed by Republicans, not Democrats, in the legislature. So I want to be very, very clear. The Constitutional Commission is advisory. A lot of the things that people like go out the window. Transparency. There's no transparency once Todd Gilbert exercised the Republican option, because the Supreme Court doesn't have to do transparency. There's no requirement that they follow any standards, because the criteria affect the legislature. If we gerrymander, we can't, because we have passed a criteria bill. It's actually my bill that was put into Sia Price's bill that prohibits gerrymandering. If you vote no on the amendment, we, by law, this passed into law, are prohibited from gerrymandering. The specific language is, we cannot draw maps that unduly favor either political party. I know that language because I helped write part of it. I had a more complex mathematical way to do it, but you can't favor any political party. So is gerrymandering allowed if the amendment passes? Yes, because there's no prohibition against gerrymandering in the amendment. If you vote no, there can be no gerrymandering by law. And people are saying, well, we don't think an independent commission will pass. It didn't pass. It did pass the House this year. The House of Delegates voted for an independent, nonpartisan redistricting, exactly what Craig wants. It's true that it did not pass the Senate. And I think it's because this constitutional amendment exists. I want you to think about the politics at play here. Republicans have always supported gerrymandering. They've always opposed anything else. In 2019, Mark Cole killed, there were a dozen constitutional amendments to stop gerrymandering. Republicans killed them all, except this one. This is the only one they would allow to go through because it had this Republican option, this kill the commission option, where, when is 2 greater than 14? Two legislators have more power than the other 14. The citizens don't matter. If all 8 citizens love a plan and 6 legislators love the plan and Todd Gilbert and Mark Cole say no, it's a no. 2 trumps 14, and it all goes to the Supreme Court. And I guess the one thing I want to say is this. I know the proponents of this amendment have worked really hard. I've seen them. I've seen them every year. I see them every year at the polls. For One Virginia 2021, do you oppose gerrymandering? They asked my constituents, and my constituents say, yes, I oppose gerrymandering, sign here. And they sign, not I oppose gerrymandering, but they sign in support of an amendment that is never shown to people. People haven't read the amendment. With due respect, the vast majority of proponents of this amendment have not read the amendment. And how do I know they haven't read the amendment? Because they say all kinds of things that they wish were in the amendment, that I wish were in the amendment, but aren't there. We all want puppies and fairies and rainbows. But let me just give you a very quick list of things.
Well, Mark,
Delegate Levine a second speaker here, or is he part of the audience?
Well, I will say Delegate Levine is part of the audience. I did, since he is a member of the legislature, and this has been brought up and discussed, wanted to touch on a point that both for Delegate Levine, and then also I know there's a lot of informed people in the audience, on the legislative guideline piece. So the legislative guidelines, and this is a question that came in by email. There's been some statements that, and I believe Delegate Levine, you just said, the Virginia Supreme Court would not follow the legislation regarding redistricting that the legislature passed. The question is, aren't all laws simply a clarification of constitutional norms? How would this law be considered different? How could the highest state court simply ignore the state law?
Because the law does not bind the Supreme Court. The Constitution does. Here's the problem. The amendment does not say, sometimes in this document, the Virginia Constitution, and actually, if you look throughout Article 6, when it talks about the judiciary, it says the judiciary must rule according to law, must rule according to the General Assembly. You read mandamus, read about court things. Everything in Article 6 says it's established by the General Assembly, except this. This constitutional amendment is the first amendment, as far as I know, in Virginia history, that does not require the Virginia Supreme Court to follow what we established in the General Assembly. All it says, and Craig had it up there, is the Supreme Court shall establish the districts, period. No recusal, no legal standards. And any lawyer will tell you, if you have a conflict between the Constitution and a law, the Constitution always trumps the law. Laws are declared unconstitutional all the time. You never found a Constitution declared illegal. So we cannot constrain the Supreme Court. We could if we did it by law, but you'd have to vote no on the constitutional amendment because laws only work if they're not superseded by a constitution, which is why putting in the Constitution, the Supreme Court does not have to obey the General Assembly is a really bad idea.
All right, thank you for that. So I want to go.
Maggie, can I see something floating through in the chat, and that it's this sort of declaration that the Supreme Court will rely on special masters or has to or always does or something. That's not the case. Just read the language that Mark just referred to again. It would be nice if they had special masters and they were a brilliant political scientist or psephologist or whatever, but that's not required. And the recusal thing, I understand. I wish it were going to be true. You know, I mean, I hope a guy who was in the legislature, you know, wouldn't be part of it. I hope the sister of a state senator wouldn't be part of it. I hope that Ken Cuccinelli's, you know, right-hand guy wouldn't be part of it. But we just don't know that. I am not willing to take a chance on that.
Isn't there?
All right, going back to the queue in the chat. Ankit, you had your hand raised.
Yeah, so I think a lot of what you're saying, Craig and Delegate Levine, is kind of premised on the fact that the Virginia Supreme Court would draw partisan maps, and the commission would fail only if the Republicans thought this Virginia Supreme Court would draw partisan maps. Otherwise, they would have no interest in kind of, you know, nuking it. So my question is, can you, courts have been drawing maps a lot over the history of this country because unfortunately our politicians don't always do it properly. So my question is, can you guys point to any single instance in the history of this country where a court has drawn a gerrymandered map?
I don't know that. I mean, I'm a, you know, sort of armchair psephologist, but I don't know that. I could go back, and I believe we probably could, you know, could come up with some. I hope they get a special master. Like I said, it is simply not required of them. There are no standards. They will have a constitutional provision that says the Supreme Court shall establish the districts. That's a little flat for me. Thank you.
So in 48 states of the United States, the people have power over the courts. In 48 states of the United States, we either, that those people either elect the judges directly, or they elect the governor who chooses the courts directly or indirectly. There are only 2 states in the United States where the legislature chooses the judiciary without any governor involvement. It's Virginia and South Carolina. So the judges of Virginia are far less independent than in 48 other states. But if you want an example, sorry?
Do you have a specific example of
So to give an example,
place where a court has?
So just this week, the United States Supreme Court said that 1 million Florida voters who have to pay a poll tax. Now, the Constitution of the United States says poll taxes are illegal, but we all know that the United States Supreme Court, who, let's face it, it's majority conservatives and they don't want more conservatives, said we're gonna really ignore the Constitution and say that all these Floridian—
Okay, but I do want to, the question was specifically on the maps. So that's a little, I understand, but I know there's a lot of hands raised.
Well, the example would be Pennsylvania, one where the map favored Republicans, not as much as the legislature did. Part of the problem is that most gerrymandered maps are drawn by Republicans. The vast majority, Maryland would be one counterexample, but most are done by Republicans. And so what you find is that courts tend to undo those. But again, these are courts appointed by the governor. What you're talking about is a very small subset, Virginia and South Carolina. And there are examples of courts that have allowed gerrymandered maps. Even the one in Pennsylvania was gerrymandered in favor of Republicans. It just wasn't as badly in favor of Republicans as the legislature tried.
Okay, thank you, Delegate Levine. Lillian, you've had your hand up for a while.
Thank you very much. I loved your sausage slides, by the way. The problem is, and I love fairies and puppies and kittens, it sounds great to me, but the Virginia Constitution doesn't give us the option of crafting the ideal commission that you guys would like. We have to go through the legislature. The legislature is a sausage factory. In 2019, there were very good proposals that could have been on the constitutional amendment track that were killed by Democrats in the Senate. We've had promises again, and I watched a live stream as Democrats in the Senate killed an anti-gerrymandering provision that we fought tooth and nail to get in there, and Democrats in the Senate killed it.
In 19, they were in a minority. How did they kill it?
I looked up that vote. What's the name of the bill?
I watched the live stream when it happened.
There was one Democrat, Lillian. I looked up that, after you said that last week, I looked it up. I looked up every single proposal in 2019. And every single one, the Democrats voted against for ending gerrymandering. The Republicans voted no. There was one exception. John Edwards joined the Republican majority. So you're right that one Democrat did.
You've told me that you liked the original one Virginia proposal, right? That was a true, you liked it. It died in committee in a Democrat-controlled Senate.
Mark Cole killed it.
I'm sorry.
Oh, no, first of all, the Democrats didn't control
the Senate. Out of committee in a Democrat majority.
The Democrats did not control the Senate.
By the way, can I please finish my sentence here?
Actually incorrect.
Thank you. What we're saying here is that we can't trust politicians on the commission, but we can trust them to do this the old-fashioned way. And we're saying that somehow it's nefarious to have our Supreme Court as a backstop when many redistricting proposals have the Supreme Court as a backstop in various states. And the idea that, okay, it sounds great to say that the people choose the Supreme Court where justices are elected. You want hyper-partisan? Think about elected judges for a minute. And then the last thing I'll leave you with is, let's just try a thought experiment here. Imagine that Ed Gillespie is governor. Imagine that there are Republican majorities in both houses. Are we having the same conversation about this amendment? Thanks.
We have to point out in 2019, the Republicans controlled the Senate. They may have gotten one vote, but Republicans control the Senate. Republicans are the people who put in the poison pill, which unfortunately George Barker swallowed.
I watched it. I saw his face. I saw his face.
Whose
And he's
face?
a Democrat. I mean, we're getting promises from Democrats that never get filled.
So I think that politically, look at it from the position of the Republicans, all right? They think they've got this wonderful amendment that's going to let them gerrymander through the Supreme Court. You have Todd Gilbert crowing about it. Okay, if it fails and we come back next year, the Republicans will have two choices. They'll either have to agree with the vast majority of Democrats who support an independent, nonpartisan redistricting, or they'll have a Democratic gerrymander. I have no doubt that we will get unanimous Republican support for the independent commission we want, because they would prefer it over a Democratic gerrymander. Remember, all it would take would be 6 Democrats in the House of Delegates, and I'm one of them, and 90% of us have said we support this, and 2 Democrats in the Senate to join with all Republicans to get exactly what we want next year. The reason we couldn't get it this year is all Republicans block voted for the constitutional amendment. They see it as their ticket to power. But once the constitutional amendment is off the table, now we have, I would bet, Lillian, I will bet you if this amendment fails, we get unanimous support for independent, nonpartisan redistricting in 21.
Kittens, puppies, and fairies. And Sam,
Okay.
But at least it wouldn't be.
the Democrats in the Senate voted for this. Are they as naive and self-destructive as you're saying they are?
So I've talked with senators about it, and they believe that the politics of this, not the reality, not what's in the bill, they don't think it's a good thing to be in the Constitution, but they think that the politics of this, they think they look bad if they switch their votes. And that's the private conversations I've had.
Plus, I'd just like to add that we can talk about butterflies and fairies and all of that, but at least it would not be butterflies and fairies in the Constitution. That's my major problem, is you put it in the Constitution, almost everybody in favor says, well, it's not perfect, and it isn't. I think it's terribly flawed. But it would be in the Constitution, and you will not get it out. You will not change it. It will go through the same process. And it's taken us this long to go to a bad result. Think how long it would take it to get out of it.
Okay, thank you, Craig. I want to address a few things in the chat right now, because there's some questions about the purpose of today's conversation focusing on opposition to the amendment. That is why we have our 2 speakers here that are grassroots advocates in opposition to the amendment. We have a lot of questions, and yes, we've had the same people attend both events, which is great. But if there are more questions, please raise your hand. I know we've had a lot of kind of continuing conversation, but I know there's a lot of hands raised. So I want to kind of move it along, but just reemphasize that, yes, this is a conversation with the grassroots activists that oppose the amendment. So with that, Elaine, I see your hand raised. I don't think you've commented yet.
Ankit asked my question, so I don't need to.
Okay, thank you. So then next I see Carol Fontaine. You had a question or a comment?
Yes, I just wanted to say I grew up in Arlington, and I still do not trust our state Supreme Court. I think and I do think that the politics in the legislature, both the House and the Senate, have been changing. And I don't trust the Supreme Court to do justice to this. I do trust Mark and his colleagues, and I trust that the senators will come around on this. I'm worried about how we make it clear that we are in favor of transparent, and I'm all in favor of what this is trying to do, but I think that we're shooting ourselves in the foot, and the fact that the Republicans are excited about this makes me really, really nervous, and I'd rather trust Mark and his colleagues to fix this when they go back.
Thank you, Carol. I do see a number of other hands raised.
Stuart actually has his hand up.
Oh, to Stuart. Then why don't we go to Stuart and then David?
So a question for you, Craig, and Delegate Levine. The League of Women Voters is a pretty serious, this is a pretty serious issue for them, and they have supported it. So what is their answer to your charges that it's neither independent nor nonpartisan?
Well, my answer is I'm a member of the League. I'm surprised I haven't been kicked out. But I think everybody has worked on this so long, to be perfectly honest, that they're willing to accept this. I understand that. I'm just not willing to accept it because I think we can do better, and certainly do better than locking this into the Constitution of Virginia.
Stuart, if you get a chance, you might want to watch my speech before the League of Women Voters last November. I read their literature, and their literature didn't even mention the Supreme Court. Much like the proposal last week, most of the proponents don't even mention that the Supreme Court is extremely likely, or even has a possibility, that if Todd Gilbert wants it to, the Supreme Court decides this issue. They don't mention it, and I went up and I did a speech there.
Well, Delegate Levine, last week we did state that should the commission not agree, it would go to the Supreme Court. That is.
To be clear, I watched the presentation. It wasn't mentioned at the whole beginning of the presentation. It did come up in the questioning. But my point is, and this relates back to Lillian's point, every election day, I go out, primary, general election, I visit all my precincts. It's just my standard election tradition. And every election I see, I represent 23 precincts. About half of them had One Virginia 2021 people there at tables. And they would say, do you oppose gerrymandering? And my constituents, the vast majority of us oppose gerrymandering. They said, yes, I oppose gerrymandering. Sign here. But they wouldn't be signing, I oppose gerrymandering. They'd be signing, I support this constitutional amendment. At not one of those sites, and by the way, I've seen One Virginia 21 do this dozens and dozens of times. I have never seen them hand out the language of the amendment. It's not that long. It's about 3 pages. They never say what's in the amendment.
I've done that. I've handed out infographics. I've handed out the text of the amendment. I've discussed the provisions with people. So forgive me, but
I've never seen the text handed out. I'm glad you did that.
There isn't any.
But there are a number of things that were said last week that claim to be in the amendment. I just want to go through this quick list of things that were said last week.
Delegate Levine, just because we are limited in time, if you have a list, you can feel free to put it in the chat. Feel free to send us the link. We can put it in the resource folder.
But I think I could say it in the
well,
minute.
but like there are a number of other hands raised that this is the grassroots activist conversation on the amendment. So with that, I see David Tate, your hand is raised.
Yeah, so it seemed like a lot of the argument against the amendment does hinge on the behavior or perceived behavior of the Supreme Court. And so I've got kind of a twofold question. One is, if they're actually going to produce a gerrymandered map, how exactly does that happen? Do they sit down themselves and draw the map? Do they actually appoint someone that is then highly partisan, which seems to be obvious? And then the second part of it is that if the Supreme Court is really that corrupt, and keep in mind the Constitution has some things where the legislature can actually try to remove or reprimand or censure a Supreme Court justice. But if they're really that corrupt, shouldn't that be an issue in and of itself? I haven't really heard that talked about. But it seems like that's what you're saying. They're so corrupt they won't even do what is the spirit of this Constitution amendment that's in the Constitution that they've pledged to adhere to. So this is kind of a twofold question. If you could address both aspects of that.
Well, first, the amendment sets no standards. It's that they shall, establish the districts. How they establish them is not there. They can. I think the view of the proponents is that if it went to the Supreme Court, there would be special masters. And by the way, special masters are usually liberal college professors. that sort of thing. But there's no, I mean, we have, like in Fairfax County, they have plenty of special master material that is pretty doctrinaire. That would be my view. Mark may have some other view of it.
So the idea that they're corrupt, they are only required to follow the law. They're not required to be fair. There's no requirement they be fair. That's not in the amendment. There's no requirement they not favor a political party. That's not in the amendment. There's no requirement that they not gerrymander. That's not in the amendment. There's no ethical standards. There are none. The reason is, like, they're not corrupt when you follow the Constitution. The Constitution says the Supreme Court shall establish the districts. That's all it says. It doesn't say how. It doesn't say why. It doesn't say be fair. It's not corrupt to follow the law. And it's not corrupt to gerrymander. People have been gerrymandered. We hate it. We think it's corrupt. We think it's wrong. But just because we think it's wrong doesn't mean they don't have the power to do it, or that someone's going to come down on their head, or they could be impeached. And by the way, it takes a supermajority to impeach the Supreme Court. It has to be for bad behavior. They would be following the law. They'd be following the Constitution. We have had gerrymandered districts from the beginning of the Republic. Just if the Supreme Court gerrymanders Virginia, they're merely following the law. That's not corrupt. And what would they do it themselves? They might hire Ken Cuccinelli to do it. They might say, hey, Ken, you draw the maps. Or they might do it themselves. But remember, you know, Ken Cuccinelli, Justice McCullough might go to his old boss, Ken Cuccinelli. Maybe Teresa Chafin would go to her brother, who sits in the Senate. These are partisan Republicans chosen to be partisan Republicans. If you want to know if they're partisan, look at what happened to Justice Jane Merrim Roush, who was a bipartisan jurist, who was supported both by Terry McAuliffe and by Dave Albo, the Republican chair of the Fairfax Courts of Justice. She was set out on her ear, not because she was a Democrat, but because she was fair. And the Republicans said, we don't have to have fair judges. We want a right-wing judge. We don't want someone who's fair to both sides, supported by both sides. So they've been packing the court with these partisan Republicans. And the last thing on this, because I saw Lillian write in the chat room, well, Democrats voted for this. We did not have a choice. Teresa Chafin's name was offered. We could vote for her or we could not vote. It's kind of like voting for Putin. You can vote for Putin or you could not vote. The tradition in the General Assembly is when there's one choice, we all vote for that choice. And the example of that would be the Speaker of the House. Todd Gilbert voted for Eileen Fillercorn to be Speaker of the House. Now, either you think Todd Gilbert is a closet Democrat and all the Republicans are closet Democrats because all of them voted for Eileen, or you understand that our tradition is when there's one name on the ballot, we vote for that one name. I voted for Speaker Bill Howell. I did not like Speaker Bill Howell. He was not my choice for Speaker, but we were given one name on the ballot and we voted for it. That's our tradition. We did not get a choice on these Supreme Court justices. And it's important that no one gives us that line, well, Democrats voted for it. When you get one choice, it's considered disrespectful not to vote for that one choice. Those are the traditions. I didn't develop them.
Thank you, Delegate Levine, for that background. I do want to say there's a number of hands still raised. Julia, you're up next.
Thank you. Thank you very much, Maggie. So I would just like to make a few points. I'm on the board of the League of Women Voters of Virginia. The League of Women Voters did a careful analysis of the constitutional amendment, including when it was changed. They analyzed it again in order to determine whether they would support it. And they decided it was a positive step forward, and therefore they would support it because it was better than full-throated gerrymandering. It does result in a citizen-led commission, and that is important. It also adds racial and ethnic fairness directly into our Constitution. It requires that all laws and judicial decisions addressing racial and ethnic fairness, not just the Voting Rights Act, which everyone in opposition loves to refer to, but all of those laws will need to be followed in the drawing of lines. And that's super important. It does help protect racial and ethnic minorities. And in Virginia especially, which is a former pre-clearance state and still will be if Congress restores the formula, this is super important. Furthermore, I think it's important for me to address the allegations about the court. I think everyone in this room, almost hopefully, is a pretty passionate Democrat and has worked very, very hard on campaigns. So I agree with what Maggie said at the beginning, that this is a conversation among family and reasonable minds can differ. I will point out that the Supreme Court does seem to abide by the principles of judicial ethics. I'm a lawyer, and we take an exam on legal ethics. The judges also have to abide by canons of judicial ethics, not just legal ethics. And the point of these is you have to take off your partisan hat. Now, not everyone does when they're judges, but good judges do. And while I'm not saying that they're saints by any means, I think all you can do is look at their actions. You can't just listen to the words that come out of people's mouths. What have they done? These guys just upheld Governor Northam 3 times in cases that are very partisan. And if they were just knee-jerk, Make America Great Again, jingoistic Republicans, they would not have upheld that gun ban in Capitol Square, okay? Because that's a very partisan issue. That's Second Amendment rights. They ruled against the Second Amendment advocates. They ruled for Democratic Governor Northam, and they upheld his gun ban. They also ruled for the governor on his mask restrictions and other COVID-related restrictions. Again, this has devolved into real partisanship with Republicans saying, oh my gosh, we have to restart the economy and get everyone out there and don't worry about masks. And the Democrats seem to be the ones who are saying, let's abide by science. And those restrictions were upheld by this Supreme Court of Virginia. So, and there was a third case as well. So my point is, if you observe the actual actions of this Supreme Court, they don't seem to be acting like knee-jerk Republicans. They seem to be looking at the law and looking at what it tells them. Finally, I would like to make one point about what happens with a special master. So far as we know, special masters are always appointed by courts. And I'd like to talk about a very important recent case where that just happened in Virginia, and then I will wind up, Maggie, swear. So last year, the Bethune-Hill case, a special master who laid out very carefully all of these principles, including nonpartisanship that he was carefully following, he redistricted a ton of districts in between Richmond and Newport News. He followed, the general principles of communities of interest and took very careful steps, and the Democrats were watching with interest because it was known that if you uncracked these districts, it should help Democrats. And indeed, he did the right thing. He put more Democrats in a bunch of districts, and the ones that he put the most Democrats into, they flipped from Republican control to Democrat control. And I was following this very carefully, and I was spreadsheeting it like crazy for my own reasons. Those 4 districts out of the 5 that received the most Democrats in them, they flipped, and one of them now has an African-American representing a district that should have an African-American representing it. And that, I would say, is a triumph of fair redistricting, and that's what should happen.
But that was in the federal court. That was not the Supreme Court.
I'm not saying it's the Supreme Court. I'm saying when you put a special master in charge of redistricting and drawing the lines, generally good things happen.
But it took the Supreme Court it took the Supreme Court, go to the syllabus in Bethune-Hill. The district court employed an incorrect legal standard, number 1. The district court misunderstood relevant precedents. So this is a glorified federal court. This isn't even the Supreme Court. This is the federal court. And the Supreme Court said, no, we don't think so.
Very interesting happened in Bethune-Hill, the federal court. What happened?
And plus, Bethune-Hill controls, no matter what is in the Constitutional Amendment. Theoretically, Bethune-Hill controls what goes forward.
The nice thing about the Constitutional Amendment is that it does say that all case law, as well as statutes relating to racial and ethnic fairness, are going into our Constitution, and certainly Bethune-Hill would control. So that's a great thing.
So to be clear,
it controls whether it's in the Constitutional Amendment or not.
Federal law trumps state law no matter what. We always have to follow federal law, whether it's in our Virginia Constitution or not. I guarantee you, if you want Democrats to put in a constitutional amendment that says you must respect ethnic and racial fairness, that's easy for us to do. My amendment, and so does Sia Price's, has far more detail about protecting communities of interest. There is no protection for language minorities. I heard Chris say that last week. That's just not there, but it is in our proposal. But Bethune-Hill is an important case. It's a federal case. The lower court ruled that the Republicans could racially gerrymander. They could use race and they could racially gerrymander. And that was upheld by a 2-to-1 decision of the appellate court that had 2 Republicans on the bench and 1 Democrat on the bench. And they said, yes, Republicans, you can racially gerrymander all you want. The Voting Rights Act does not apply. The United States Supreme Court overturned that, actually unanimously, because the racial gerrymandering was so severe. And interesting what the US Supreme Court did, this is rarely talked about, is they changed the composition of the appellate court below. They removed one of the Republican judges and they put one of the Democratic judges on there. And then by a 2-to-1 decision, it turned out that yes, the Bethune-Hill case came out in our favor. But the point is, by changing the composition of the judges, we got a different result. And I wish that weren't the case. You're right, Julia, that good judges should not rule according to partisan basis. You're absolutely right. That's the way it should work. Prior to Bush v. Gore, I believed it was the way courts worked in general. But if you want an example of the Virginia Supreme Court ruling the wrong way, don't look at gun cases. I mean, the US Supreme Court ruled very well on a gay rights case. When it comes to voting rights, that's where you find conservative courts are not generally very helpful. And the clearest example of that is when Governor McAuliffe used his absolute right under the Virginia Constitution to say that everyone who was an ex-felon, he would basically restore all their voting rights. And it says right here in the Constitution, he can restore voting rights en masse. The conservative Virginia Supreme Court said, you can't do it, Governor. And their basis was not based in the Constitution. They said, it's just never been done before. And Terry McAuliffe said, well, it's right here. And he said, well, it's never been done before. And so they didn't, and when it came to voting, the conservative Supreme Court did, I think, something extraordinary. They told the governor he didn't have an express right under the Constitution. So we know he went back and did them individually. But, you know, at the end of the day, I don't trust this court. That's true. I hope I'm wrong. I hope this court can be trusted. But do we trust the Republicans, or do we allow both sides to draw the maps? And the court is Republicans.
Delegate Levine, I think you're an amazing legislator, and some of the bills you have filed are fabulous. However, I would point out that one of the main bills, which was not yours, one of the main bills which was supported by opponents to the amendment this year would have, if the commission deadlocked, it would have let the legislature draw the lines. And I firmly believe that that's not where we want to go. That's what we're trying to get away from, is gerrymandering. So, and therefore, when we talk about trust, and then we see the legislators who we trust filing bills like that, we just have to say, I think we have to take trust of the legislature out of the equation. And if we can't do that, we have to take a step along that road.
And put trust in the Supreme Court? I'm sorry, I'm taking Eileen Fillercorn over Chafin Sisson. I'm sorry.
Julia, that proposal didn't pass. The one that did pass the House, which was Sia Price's proposal, HB 1255, did pass the House of Delegates, didn't pass the Senate, is a pure independent commission. And that's something that we could do. You're right, there was a proposal, that one did not pass.
Okay.
Unfortunately, okay, stop.
So I just want to say there's still a lot of people that haven't gotten a chance to speak yet. So Janice, you've had your hand raised for a while.
Thank you so much. I just wanted to ask, I sent a question earlier in advance of the meeting about what happens, I mean, if you don't have a constitutional amendment, which is binding, and you go with a non-binding legislative solution, what happens if, by God, the Republicans get back into office and there's nothing that prevents them from changing the redistricting lines to their benefit, ultimately? And does anybody have an answer to that question?
So there's just sort of 2 subpoints to that. One is the question of mid-decade redistricting. It was suggested last week that the Constitutional Amendment does something about that. It does nothing about that. It doesn't change that language. Just so you know the law on that, the Virginia Constitution says that we redistrict in years ending in 1 and every 10 years thereafter. Now, can we redistrict in between? I think no, but that's my interpretation of the current language, and the amendment doesn't change this language. Someone could argue, well, you have to do it in years ending in 1, but you could do it in another years too. I'd like to put an express prohibition against mid-year redistricting, which is not in the current Constitution or in the amendment. But to answer your question about standards, if the Republicans get in power, yes, they can change all the standards, including any laws that we write. They can throw them out the window, which is why I do want to see a constitutional amendment. I put forward a constitutional amendment. It takes 2 years, and we Democrats won't control for 2 sessions in a row unless we win in 21, and we could do that amendment 21 and 22, and then we can bind everybody. But you're right that until that happens, any General Assembly can change the law.
So yes, so that is a real drawback of your approach in the sense that, one, realistically speaking, and I think even you would concede, you're not going to pass another constitutional amendment before 2031.
Oh,
So
sure.
you're basically, excuse me, sorry. The chances of that are impossible.
I think if the Democrats stay in power. All we need is 21 and 22, and we pass.
I apologize. I was making my point that, it's not going to, you're not going to have a constitutional amendment before 2031. So you're basically saying for the next 10 years, we're going to allow for gerrymandering on both sides.
We will have one before 2031. We won't have one before 2021. I think that's what you were trying.
Exactly. Did I say misspoke?
Right.
I'm sorry if I misspoke.
No, that's all right.
But there can be
I'm like, we'll do that. No, 2021, there has to be a legislative solution. That's true. This is the only constitutional solution. But again, given that the Republicans can throw away the commission and send it right to the Supreme Court, at the end of the day, there has to be some backstop. And that's why when Julia mentioned that a delegate had a backstop being the General Assembly, there has to be some backstop.
And the backstop would be a constitutional amendment, I would say.
Well,
the other more binding way to approach it.
Under the amendment, the backstop is the Supreme Court. The Supreme Court shall establish the districts, no guardrails, no protections. They do it. Or the backstop is the General Assembly. One of the reasons why I think Republicans will unanimously support the independent nonpartisan commission that Craig supports, that I support, and frankly, the vast majority of your Democrats in the legislature are on record as supporting, is because once the amendment dies, they could kill it last year. Once the amendment dies, they'll have no choice. It will be independent nonpartisan redistricting or a Democratic gerrymander. So
doesn't it make the point even stronger that we shouldn't let the amendment die and put everything back into Republicans ultimately?
No, absolutely not.
So I do want to note there's been people with their hands raised for a very long time. So up next is Mary Detweiler, and then Michael and Barbara Raisin.
Okay, thank you. I have been watching this since last winter and much earlier as well, and I really have been very much on board with the proposals back in 2019. I've been looking at this term bipartisan quite a bit, and it sounds wonderful, but I think sometimes it gets interpreted as the ultimate good, when in this case, to me, it seems like it's accommodating blockage. And I really want us to think in terms of always going toward independent as opposed to bipartisan. So many other points I was going to make have already been made, but let me just go back onto the PR optics. I know that has frightened a lot of people. And like, as Craig has said, broad shoulders, we're going to have to stomach that as we get through it. But I think we would have to make pledges to hold our elected officials accountable for anything that does not happen next winter.
Pledge.
And we have to put that in writing, and we have to publicize that, and we have to swear up and down and pledge our firstborns and all that. The second thing I wanted to mention was, I don't think it's fair to say that those who are not on board with this constitutional amendment are necessarily calling Virginia Supreme Court justices corrupt. To me, there is a mindset, and cognitive linguists have studied this for many years, all think about George Lakoff and all that. There is often a way of thinking. It may be so deeply embedded into one's ideology that you don't really know that you are moving in that direction. If you are a conservative justice, I think you're more likely to want to be conservative, not change the status quo, keep things pretty much as they are. And if you start redrawing districts to be drastically different, that may be uncomfortable for you. So it's not that I distrust Virginia Supreme Court justices because I think they're corrupt. I do not. I think they are probably good, decent people, but they may have a mindset that is not going to perhaps choose the map drawn by an outside drawer of those maps that would be one that I would like to see drawn. Thank you.
Just to what Julia just put up in chat, she says the justices don't draw the lines. The justices establish the districts. You can say, oh, well, somebody else is in the back room with a pencil or the supercomputer or whatever. But that idea that they don't draw the lines, they do draw the lines. Whether they draw them with their hand or let somebody else, the Supreme Court shall establish the districts.
Kind of like saying Trump doesn't build the wall. He doesn't physically put up the wall. He hires people to put up the wall.
Okay, thanks. I do want to get to Michael and Barbara Raisin. I know you've had your hand up for an extremely long time. Please go ahead.
Yeah, I think there's minimal risk to having this amendment passed for redistricting, and it won't be having gerrymandering in the title at all, but it'll be called redistricting. And the reason being is that we have Democrats right now that are ruling the Virginia representatives and the Senate. So the Speaker of the House is also Democrat. There is not a big problem, and if things all go amok in the next couple of years, this can be reversed very easily. It's hard to get something instituted, but to reverse it, it's just going to go like that. And I think we waited so long for us to wait another 12 years with all the inertia, and I see so much inertia on a local level, on a state level, on a federal level. I'm really fed up with how it's just about a paycheck now for our government. We really need people with passion, and we need to go forward. And I think that if we make this step, we'll have a commission of 8 independent people doing the process. And I think we'll all be able to really, like Mary said, put our passions into monitoring how those commissions are made. And if we keep going like this, what do we have?
Okay.
That's my opinion.
I would like to add that you're arguing over eventualities, that if the commission doesn't agree,
No, if 2 people in the commission don't agree.
Todd Gilbert says no, the commission dies.
Todd
Gilbert says no, the commission dies. Keep remembering that in your head. This wonderful commission goes in the trash if Todd Gilbert says no, and one of his friends in the House of Delegates. So it sounds wonderful, but when you say it can be easily reversed, if Todd Gilbert says no and exercises the Republican option, which Craig calls the poison pill, it goes to the Supreme Court. Do not pass go, do not collect $200. All that good work of those citizens goes in the trash, and they'll be crying maybe over it. It goes to the Supreme Court. If the Supreme Court draws Republican gerrymandered districts, then we won't be in power in 22. We won't be in control of the House in 22. There will be no way to reverse it, because the only to reverse the constitutional amendment, it must pass the House and the Senate. If we don't control the House of Delegates because the Supreme Court did a gerrymander, then we can never undo the Constitution. So this idea that we can reverse it in a few years, please understand that in 2017, before Bethune-Hill redrew the districts, Democrats won 55%. I counted the votes. 55% of Democrats in Virginia voted, 55% of Virginia voters voted for Democrats. We had a minority in the House of Delegates because it was gerrymandered. If the Virginia Supreme Court simply restores the 2017 maps without racial gerrymandering, because that's not allowed, but does political gerrymandering, which the US Supreme Court has said, you can politically gerrymander all you want. North Carolina, you can have 10 Republicans and 3 Democrats. We're fine with political gerrymandering. If the Virginia Supreme Court follows the US Supreme Court and does a massive Republican gerrymander, we can never take this out of the Constitution because we won't be in power in 2020.
How are the legislatures that are going to be on this commission chosen? You're assuming that Todd Gilbert is going to be on the commission.
He is.
Todd Gilbert,
you don't have to worry about that.
Todd Gilbert chooses himself and another Republican delegate. And if he and the delegate he chooses votes no, then 2 trumps 14. It's very important to understand that. If Todd Gilbert and his friend decide to kill the commission, it doesn't matter what citizens, it doesn't matter who's the leader of the commission, it doesn't matter who the Democrats choose, it doesn't matter who the citizens are. The amendment says, and I want everyone to read Section D. It's very important that you read the entire amendment. Section D says, if you don't get 3 of the 4 legislators supporting a delegate map or a Senate map, all state maps die. So if Todd Gilbert,
isn't there going to be implementing legislation that will direct the Supreme Court to appoint a special master?
No, there can't be, because the Constitution says the Supreme Court shall establish the districts. There's no requirement of a special master. There's no requirement of recusal. There's no requirement of being fair. There's no requirement of following ethical standards.
Now,
None of it.
But now that's the case. But how about if we get implementing legislation that the Democrats will pass?
So the problem with implementing legislation is that a constitution trumps a law.
Yeah, once it's there.
If we were to vote down the amendment, then we could vote in legislation that would control the Supreme Court. But when the Supreme Court is looking at the Constitution versus a law, they just follow the Constitution, because laws that don't follow the Constitution are called unconstitutional. They have no meaning. So the only way to restrain the Supreme Court would be to vote down the amendment.
Clarification, the two legislature vetoes apply to the state maps, but not to the US congressional maps. Am I right?
Yes, it requires 3 legislators to veto.
Thank you.
Okay, thanks. I do want to note, it was put in the chat, a resource about how the delegate or the commissioners would be selected. And there are, by the proposed amendment, seats for both the majority leader and the minority leader of each party in each chamber. So that is part of what's on the
That's how
table.
Todd Gilbert gets there.
I do want to recognize there's still a lot of people that have not spoken yet. So up next in the queue is Chris DeRosa.
Hi, thanks. I've got a lot to respond. Let's see if I can read my handwriting. So one of the important things about the Constitutional Amendment is that it will require transparency. So no matter who's drawing the maps, we will be able to watch them carefully. Delegate Levine, I don't know why you're shaking your head.
Because it doesn't require transparency for the Supreme Court. It does require transparency for the Commission. But the Supreme Court,
if it goes to the Supreme Court, they have to abide by the Constitution. So if the Constitution says all meetings shall be open and all records shall be open.
It doesn't say that. It's not in the amendment, Chris.
It's
is. Not in the amendment that all meetings must be
There are
open.
also protections for minorities, including language minorities, in the language of the amendment.
No, ma'am. Tell me what section, what paragraph. I have the amendment in front of me. Where does it say there's protection for language minorities? It's not there. Tell me the paragraph. It's not
I don't
there.
have the paragraph in front of me. I have read the amendment, though.
Okay, I think you think it's there. I respect that you think it's there. I ask everyone in this room to please read the amendment word for word. You will not see the word language anywhere in the amendment. You will not see communities of interest.
And I think, Maggie, I have sent you copies of the bills, so they are in your folder.
Yes, the copy of the proposed
read them.
amendment, as well as the language that will be on the ballot in November, is in the resources folder, the draft language.
And you will not
There is
see
also
language
SB
minorities.
17, which was written by Senator McClellan, and that does address more criteria, such as it does require that communities' interests be respected. And there is language in there that says the map shall not duly or unduly favor a political party.
Great
So
language,
that's-
I helped write it. It constrains the General Assembly, does not constrain the Supreme Court. So the only way to get that language to be in there is to vote no. Just to be very clear. It's great language. I helped write it.
The Supreme Court shall
You don't have to
establish
vote
the
no.
districts.
You can vote yes to this constitutional amendment. If you would like to improve it with another constitutional amendment by adding more language in the future, I think that would be great. I will support you or anyone else who tries to do that.
I do want to note to just maybe have one more comment, because there's still people that have not spoken yet.
Can I ask Delegate Levine one question?
Yes.
Yes.
The members of the Supreme, and well, two things. I don't like Todd Gilbert any more than you do, but I don't need to hear his name all the time. Supreme Court justices, most of the, I think all except one were approved by unanimous vote of the General Assembly. How many of them did you support and how many of them did you
I
vote?
supported none of them. But to be clear, the tradition in the General Assembly is that when there's one name on the ballot, we vote unanimously. If you think Todd Gilbert supported Eileen Fillercorn for Speaker, he didn't, but he voted for her because we unanimously voted for her. We also unanimously voted for Bill Howell, the Republican Speaker. I voted for Bill Howell because the tradition in our chamber is when there's one name on the ballot, we all vote for them. It's considered disrespectful not to. The last time someone didn't vote was Tracy Thorne-Beglin 10 years ago. It was a huge uproar when Republicans didn't vote for the first openly gay judge in Virginia. The tradition is that majority party picks the name and we all vote for them. I wanted Jane Merrim Roush. I wanted her to be there. The Republicans removed her, put in McCullough. But again, don't let the fact that there's one name on the ballot and we all voted for that name, that doesn't mean anything. That's a tradition. Like I said, Todd Gilbert voted for Speaker Fillercorn. That doesn't mean he wants her to be Speaker.
Maggie,
Okay. Yes, Craig.
Chris, I too would love never to hear Todd Gilbert's name again. That would make my day, my year, my life, my millennium. But we have to hear his name because he, in fact, will be, he's guaranteed by the, amendment, a seat on the commission. All he has to do in a legislative situation is to get one other member to send it to the Supreme Court. In congressional, he only has to get 2 more. Something tells me he can get those people. I know, I will bet, I am a betting man, I'll bet that he can get those people. I bet he can queer the deal. That's what he has said he wants to do. That is the way, basically, I think in Virginia today, it's the only way he and his Republicans get back in power. I do not understand why we are shooting ourselves in the foot or even some more critical piece of the anatomy.
Thank you, Craig. I did want to know, Jeff Lawson, your hand's been raised for a while, and I don't think you've had a chance to ask a question or comment.
Yeah, it's funny. Craig just sort of touched on this. My question is, what is the likelihood that this would actually get sent to the Supreme Court within the next year or so? Or could enabling legislation or a Second Amendment be passed before it actually gets pushed to the Supreme Court?
Not another amendment. There's not enough time.
If we vote no, it won't go to the Supreme Court. If we vote yes, it will almost certainly go to the Supreme Court, because the commission will be an advisory commission, and Republicans have shown in 2011 that even when their governor supports an advisory commission, they don't obey it. Republicans have been consistent. Democrats argue about gerrymandering. Republicans don't. They say, we want a Republican gerrymander. We've always wanted a Republican gerrymander. We'll do everything we can to get a Republican gerrymander, and this amendment is our key to getting it. They're very consistent about this. We have qualms because we know that we believe gerrymandering is wrong. Republicans
Was a question about whether legislation can be passed with more criteria? Did I understand that right?
It can be passed with more criteria, but it doesn't trump the amendment.
Is that what the question was? If it's in the Supreme Court, if it's in the Constitution, it's there forever. So even if it doesn't happen to go to the Supreme Court before 2021, it could happen in the future. The question is, would it get sent to the Supreme Court before 2021, or is there actually more time for enabling legislation to happen?
There isn't. The amendment.
There is time.
The amendment that we have, in fact, honestly, I'm not even sure we can get it done according to the amendment, because the timeframes in the amendment, given that the Trump administration.
So I want to say, I think the question really is, would enabling legislation provide enough guidance? Not another amendment.
Right.
Enabling legislation passed by the General Assembly.
Cannot constrain the Constitution because constitutions trump laws.
Enabling legislation
can constrain the General Assembly, and in fact does. We passed enabling legislation. It constrains the General Assembly with criteria. It can prohibit us from gerrymandering. It cannot prohibit the Supreme Court because it's not in the amendment. If the amendment allowed for enabling legislation, then it could, but it's not in the amendment. The amendment simply says the Supreme Court shall establish the districts. It doesn't say pursuant to law. It doesn't say according to enabling legislation. It doesn't say according to standards set by the General Assembly. It just says shall establish. The whole amendment can be boiled down to those 9 words. The Supreme Court shall establish the district. That's the whole amendment. The rest of it is the lipstick that people love to focus on. But the enabling legislation can constrain us. It can't constrain them because the constitutional amendment wasn't written to constrain them. That's why.
No matter when it's passed, no matter when the enabling legislation is passed, if this constitutional amendment is passed, the Supreme Court shall establish the districts.
We can do a better constitutional amendment, if that's your question, absolutely. I think my proposal is better. There are other proposals out there, but that can't pass until 22.
But you have to hold your breath because this will have passed, and that is in fact the Republican poison pill.
Okay, so thank you, everyone. It is 11:27, and I do want to respect everyone's time. Craig, do you have a final kind of closing thoughts, or?
I have a slightly humorous one. How hard was it for proponents to keep Brian off this call? And then number 2, this is messing with the Constitution of Virginia, the supreme state law. It is there. There is no, it would be so difficult to get it removed. And the poison pill. I'm sorry. People want to say, oh, you're just focusing on that. It's going to happen. You know, I understand, Chris, we don't want to hear, we don't want to hear Todd Gilbert's name, but we're going to hear it and he's going to screw us. That's the bottom of my line.
Thank you, Craig. I do want to remind everyone again, thank you to Craig, thank you to Delegate Levine, thank you to all of the highly engaged members of the Arlington Democrats and general, interested public on weighing in on this conversation. It was a really good discussion. We have recorded this. There's also recordings from last week's Morning Mug and the roundtable that Delegate Levine was a part of earlier, I think at the end of June. Time's a little fuzzy now. I want to remind everyone kind of where we're at. At the end of July, the Arlington Democrat Steering Committee is going to take a vote, and it's going to be two votes. First, whether or not to weigh in on the proposed amendment, and then second, if we weigh in, whether we support or oppose. So I highly encourage, and then after the steering committee vote, there would then be a vote by the general Arlington Democrats voting member group, which is a larger group, at the beginning of August. I will remind everyone, it is a vote within the Arlington Democratic Committee. It's not an open vote, so the voting pool is defined to people such as precinct captains, area
It's a pretty big group.
It's a big group, but it's not an open vote. But I do want to just encourage everyone, thank you for attending this. Make sure that people, either get the links to these conversations, share the resource folder, share the text of the proposed amendment, share the actual language that's going to be on the ballot in November. Those should be in the resource folder. And if you have any questions, please feel free to direct them to me. I can help connect, and I'm sure Craig and Delegate Levine would answer further questions, as well as Chris and some of the representatives from the proponent side. I know Lillian's been a big leader here in Arlington, as well as Julia. We can help make sure your questions get answered that we weren't able to answer today, but I really do thank everyone's time. And so with that,
Maggie, I think we want to thank you. You've been
Thank you, Maggie.
number one for your patience.
I'm just glad everyone's really engaged, because I will say my overall hope that we have an informed decision from the party onto how to move forward, because once we make a decision, the party is sticking by it. Like that is the vote. So thank you all, and we will have this recording available as well. I know it's been shared kind of to other jurisdictions in the Commonwealth, and I appreciate that. So if you have friends in other jurisdictions, I know the Fauquier County shared it. I think Carol shared it with the Biden group. So it is definitely something that we want to share as a resource to other parts of the Commonwealth that are considering the amendment as well.
If anyone wants to call me, email me, you've probably figured out I can talk till I'm blue in the face about this. I'm happy to chat with each and every one of you individually. And the last thing I'd say is please read the amendment and do not vote yes unless you've read every word of the amendment and you understand every word of the amendment, because people tell you things that are there that aren't there. You got to read the amendment. So it's easy to find. I'll send it to anyone who needs a copy. Read the actual text of the amendment, not the pretty glossy. You can read the pretty glossy things too, but read the actual amendment. It's not that long. It's about 3 pages. Read it before you vote.
General good advice to read what you're voting on.
Yeah.
So thank you all.
Thanks, everyone.
Have a good Saturday, and see you at some point in the future once we can stop meeting by Zoom only.
Have a good afternoon, everybody.
Cool.
Cheers.
Your comments.
Bye.